Okay. Can you hear me?
You are okay. I actually talked to AT&T, in-house counsel at AT&T. We're not but I missed training.
Alright, sounds good. I see what you're
I'm like, alright. Yeah, that was before maybe a year and a half ago.
Tested the volume.
Oh, the volume. Is this the mic? What is this now?
No, it's actually
I'm on video. Oh, man. My hair.
Alright, try to say hi again.
Hi. 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 Normal voice. Is it working?
Alright, talk.
Hello. Testing. Testing. Hello. It's not picking up.
She's saying the feed is like super low and choppy. But
Like, is it too slow? Where is she located?
she's at the office.
Oh, she's at the
watching
office.
it,
Do you think
yeah.
it's just a bandwidth issue at the office?
No, I'm thinking it's probably here.
Oh,
But I'm not too sure.
You don't have anybody else you can test it with, right? Dial into somebody else outside the office.
Yeah. I think we're good. Good to see you.
Good to see you too. Thank you for doing this. Good to see you.
She's a
Michael Roth. Hi, nice to meet you.
see you.
Sorry I didn't get that till this morning.
Don't worry about it.
I wrote it and then I had a meeting at 5.
No problem. I saw that you got it up. So
Yeah.
No.
When I got your email, I was like, oh, it's all done.
Right.
Hey, Stephanie, with regard to this webcast,
Yeah.
it's important. I don't know if Terry passes along to you. I know she's out of the office.
Yeah.
We are not an authorized accredited provider for CLE via webcast.
It's in the posting that
You revise the materials?
Yes.
Awesome. So I think we're good?
Yeah. No, thank you for
Perfect.
that.
And then we're going to take the one from October off because it's
Right.
significantly outdated.
Yeah. I know we will, and then in July
New
or
form?
whenever we'll revise it again.
Well, actually, we're going to talk about the new forms.
Oh, we will? All
We
right.
use them actually already.
Oh, nice. All right.
Hey, Bob. Here we go. How are you?
How are you? Good to see you.
Good to see you.
Do you,
Good to see you.
who has materials?
Baker was putting them.
If it was, maybe Aaron for.
Aaron's doing it, Aaron has them, absolutely.
Okay.
She's stuck on the phone right now.
Okay,
Yeah,
all
she's
right.
got the materials. And we've got plenty between end of training and when the bus arrives, so.
Alrighty.
All right, let's move. Nice to meet you, Michael Rock. Good to see you, Michael.
Tom, you ready to be on camera? Recording?
Yeah.
It's like his first time.
It's not my first time. Yes, that's all. How's my friend Katie doing?
Well, she got a tie for you.
Anyone has in their family, you're gonna call. So give them my card. And if they have any other legal issues that fall outside the scope of what we're doing today, the POAs and the living will, flag me down, have someone else, we can have a volunteer do an intake. And we do simple wills, but we just don't do them today. They have to call the center and go through the process. Thank you all again for participating. I look forward to seeing you this afternoon.
Thanks, Michael.
Well, thank you, Michael. Again, my name is Tom Wett. I'm the Chief Legal Officer for the Center for Disability and Elder Law. And what we're going to be doing today is looking at our Senior Center Power of Attorney and Living Will Initiative program, and specifically how this program operates on a practical level, and going over how the forms are to be filled out the way that we are filling them out for this program. Many, if not all of you, have probably used powers of attorney for other reasons. We're using them as part of or in lieu of a more formal estate plan, allowing the principal to appoint an agent to make decisions for them in the event that something happens to them in the future, and because of a lack of capacity, as opposed to many of you may have used them for real estate purposes or something like that, where somebody's going to be temporarily out of town when there's a real estate closing, so they're giving their spouse or significant other or attorney or whomever a power of attorney for property to sign off on closing documents, for instance. Our focus is very, very different. So as we go through them, we will highlight what those differences are. I know many of you have gone through this program already. However, it's always not a bad idea to go have a refresher. And in fact, there have been some significant changes to the power of attorney statute and the subsequent forms. And we're going to talk about those changes as we go. Because we only have an hour, I'm going to dispense with some of the sort of overview things about what powers of attorney are and who's an agent, who's a principal, that sort of thing. But I do want to mention a couple of parts of this. Under the statutory forms, the principal can only name a agent at a time. Co-agency is not permitted under the statutory forms. So if somebody says they want to appoint both their son and daughter as their agent, they can't do that. What they can do is they can name one as the power of attorney for health care, the other one as the power of attorney for property. That would be within their rights. Or they can name one as the power of attorney for health care and property, and name the second child or second person, whomever that may be, as a successor agent. And we'll see in the forms when we get to that point where that's designated. As we probably all know, an agent can be anybody you choose as long as the person's at least 18, has the capacity to make their own decisions, and under the power of attorney for health care, the principal may not name their doctor or primary health care provider as their agent. Other than that, it can be anyone else that they choose. Typically, it's a family member. It's recommended that the agent be younger and in better health than the principal, again, because these are intended to be durable documents intended to be used in the future. Somebody names mom as their agent, it's quite likely that mom would predecease or become incapacitated prior to the principal. So it's recommended that the agent be younger and in better health. As I mentioned, principal can name successor agents, and they may name as many successor agents as they choose, but they cannot name co-agents. We go out in advance. I was actually at Abbott Park, where we're going today, just last week, talking to the seniors. I was also there in January, and we've been there several times in the past. Talking to the seniors, giving them handouts. The handout that we provide includes some basic information about organization, and then also sort of an FAQ about powers of attorney, living will declarations, etc. It's important that they discuss these things with the person that they're proposing as their agent. Not only to make sure that the agent understands what's potentially being asked of them, but also to make sure that the agent is ready, willing, and able to step in to serve as agent should they be called upon to do so. It's one of the reasons why we include the FAQ part of our handout. So hopefully they've had a chance to talk to the person they want to pick as their agent. Maybe they've discussed what's listed in the questions and answers, and they have a good idea of what's. Our primary job is going to be tailoring the documents to the, according to the needs of the principal, to our client. Some common execution errors that we see frequently is the agent's information won't be reflected in the power of attorney. It may have a name, but that's it. We're going to see when we get into the forms what we want. We want to see the name of the principal, the relationship between the principal and the agent, and the address. The relationship is not a statutory requirement, but it helps for identification purposes. But it's important that it be as complete as possible, so if anyone is going to be relying on these documents in the future, a doctor, a bank, Social Security, insurance company, what have you, that they have reasonable assuredness that the person who's purporting to be the agent be the actual agent. It's important that they're signed. In the new statutory forms, there's a clause in there that says that the principal does not have to sign the power of attorney. And then it has a caveat saying, but the power of attorney will not be effective unless it's signed. So it wouldn't do as much good if we went through the process and didn't actually sign them. It's also important that they be witnessed. It's a statutory requirement for both the power of attorney for property and the power of attorney for healthcare, that they be witnessed. Under the new power of attorney for property form, they recommend, although don't require, 2 witnesses. It's one of the changes in the statutory forms. The power of attorney for healthcare needs a single witness. It's also a statutory requirement that the power of attorney for property be notarized. We notarize both the power of attorney for property and the power of attorney for healthcare, even though it's not required that the healthcare one be notarized, simply because we have notaries and we're doing the first one, so we might as well do both of them. Again, to give anyone who's using the power of attorney, who's accepting and utilizing the power of attorney, reasonable assuredness that it's been done correctly. Some questions that you'll often be asked at the workshop itself is, what if I change my mind? Can I change my mind? Or what do I do if I change my mind? Can I call you and you can change it? The answer is yes and no. Under the statutory forms, the agent has the right to revoke the power of attorney or to alter the power of attorney. However, any changes that are made to the power of attorney must be done with the same formalities as drafting the powers of attorneys themselves. So they'll often say, well, if I change my mind, I don't want my son to be my agent, I want my grandson to be my agent. Can't I just cross out his name and write the new name in? The answer is no. It has to be done with the same formality. What we recommend, and if anyone asks you that question, is if in the future you do want to make a change to the power of attorney, or you have questions about your powers of attorney, you want to revoke the power of attorney, call CDEL. We're happy to talk to them in the future. And in fact, as we go through the documents, we'll see the very final document that we give them is a 2-page handout about what we've done, which includes our name and address and phone number and all that sort of thing. You don't have to take it upon yourself to say, that you will personally handle it. We're not requiring that. We don't request it. We don't even necessarily want that, because we want to be able to control the process through CDEL, because everything that happens has to go through a certain procedure. But if they do have questions, or if they think they're going to have questions in the future, feel free to give them our card if Michael is providing cards. It's on all the our information is on all the forms and on the handout that I was talking about. The other question that they often get is, what happens if my agent moves? If my son moves, do I have to do a new set of powers of attorney? And the answer is no. They're still valid. If the change that's being purported is going to be a major, like changing the agent, it's recommended that the power of attorney, that a new set of powers of attorney be done. But if they're simply moving, that doesn't affect the power of attorney. The address is only there for identification purposes. The other question that we often get is, when does a power of attorney end? And under the statutory forms, the default rule is the power of attorney for property ends upon the death of the principal, unless an earlier termination date is entered. And the power of attorney for health care ends at the death of the principal, except for 3 residuary powers. The power to make anatomical gifts, the power to authorize an autopsy, and the power to direct the disposition of the principal's remains. Those 3 powers of the agent continue after the death of the principal. And we'll see in the powers of attorney forms in a moment how that's reflected. The power of attorney can also terminate if the principal decides that they want to terminate it. They can revoke the power of attorney at any time. A strange quirk in the statute also actually allows the principal to terminate the power of attorney and revoke the power of attorney, even if they lack the capacity to appoint a new agent. On a practical level, that would probably be pretty problematic, but it is within the law. In which case, then the power of attorney is terminated, and then somebody would normally have to apply for a guardianship. But under the statute, they're allowed to do that. It can also terminate if the agent wishes to no longer serve as their agent. And then finally, if the court removes the agent for improperly fulfilling their duties, breaching their fiduciary duty. If they ask you any questions about how revocations are done, under the law, it says that they can be revoked in any way, but it really should be done through a formalized process, especially if the power of attorney has actually been utilized. If they have questions about that, we're happy to discuss those at that time. What we're going to be filling out at the workshop itself is upwards to 5 distinct documents. And I want to kind of go through those in a bit of detail, and then we'll come back and talk a little bit more about the statute and the law itself. The first one is a simple screening form, and I'm kind of holding it up. You can flip back. There's step-by-step instructions starting on page 10, and then the forms themselves. This is what we use for 3 purposes, really. The first purpose is to give us the information that we need to fill out the powers of attorneys themselves. The name of the principal, the address, the name of the agent, the address of the agent, the name of the successor agent, address of the successor agent. There's a little bit more information in there that we require: gender, date of birth, income and ethnicity. Those are all sort of That's all information that we're required to keep either for our funders' purposes or for qualification for further services. For the workshop, for doing the powers of attorney, we're not really concerned too much about whether they have an income or they have assets. But if they were to request any additional services in the future, they would have to qualify for our regular program. And to qualify for the Center for Disability and Elder Law's regular services, the participant must be at least 60 and or have a permanent disability as recognized by the federal government, and also be within 150% of the federal poverty level, which is the reason why we ask for their income. And it just gives us an idea whether or not we would even be able to provide any services in the future.
Will we do that now? Income information now?
Yeah, and if they refuse to give it, we just skip it.
Okay.
We're not going to press it, but it gives us a guide in the future, because what we found a couple of times is somebody qualifies for ours, they do the workshop, and then they come back and say, oh, I need to have a living trust set up to put all of these assets in. Well, that really, they probably wouldn't qualify for our regular services, because we normally don't do trust, because we normally don't handle people who have a significant amount of assets. So it just helps us a little bit. But if they say, I'm not comfortable giving it, don't worry about it. Just skip it and draw a line through it and go on. Race and ethnicity, some of our funders, including the City of Chicago, who helps support this particular program, require us to provide quarterly demographic information, anonymous demographic information. But part of it is they want to make sure that we're assisting various ethnic groups and people of both genders relatively equally or proportionately. So that's the reason why we ask for gender and ethnicity. And again, if they refuse, you can kind of probably tell the ethnicity, but if they refuse, you can just write refused. That's perfectly acceptable. Oftentimes when you sit down with your client after the first sort of go-around that you meet with the first client, this information will actually already be completed. What we often do is we have our paralegals and other support people go around to the next group of people who are waiting to see an attorney, and we'll get this information. If it's not completed, it only takes a couple of minutes to complete. The second section of the screening form is really important for two purposes. The first purpose is to make sure that we have the documents that they want to do. Not every participant is going to want to do both a power of attorney for healthcare and a power of attorney for property. And not every participant is going to want to do a living will declaration. So we simply check off the ones that they're actually doing. And the second part of the screening form is the most important from your perspective. Did client have any other legal matters? You are under no obligation to talk to anybody about anything other than what we're there to do today. However, most of the clients that you're meeting with have either never spoken to an attorney or had limited access to an attorney, and they may want to talk about other things. Be friendly about it, be nice about it. You can ask them if they have other issues, but you're under no obligation to actually discuss anything else. But if they do have something else, they say they have a landlord-tenant issue, or they say they want to have a simple will drafted, you can simply check yes on this and then write a brief description of what it is. Client wants simple will. And then you can tell them that somebody from CDEL will contact them within the next week to 2 weeks to follow up on those issues. And it doesn't matter. I mean, even if they don't qualify for our service, we still follow up with them and we still give them some direction. But you're under no obligation to actually discuss it. When we do wills, we have a simple will questionnaire form that we fill out with people. We're under no obligation to do it at the workshop. Sometimes they'll say, can I just take it home with me? That's okay, we'll let them have it. Or we prefer to say we will send it to you through the mail. And then the last section is whoever's going to be reviewing the documents, usually Michael or myself or Ruth, although I won't be at the workshop today, so it will probably be Ruth or Michael. They're just reviewing it to make sure that the signatures are there, the witnesses are there, the notaries are there, and we have copies of all the documents that the client did. The next document is a limited client agreement, and we do mean limited. The purpose of the limited client agreement is to really define the scope of what we're doing, and more importantly, define the scope of what we're not doing. All that we're doing at this workshop on this day is to provide legal information to inform them regarding the client regarding their options about powers of attorney, helping them draft the documents as necessary, and that's the extent of what we're doing. We're not providing any additional services. We're not agreeing to assist them in the future. It doesn't mean that we won't, but again, any regular service, we go through a separate type of screening and intake process, just like any other firm would do. We're not agreeing to assist them in the future. We're not filing any sort of appearance. The documents aren't being recorded because in Illinois they're not required to be recorded. Number 3, I want to bring up, because this causes a bit of concern. We're going to be in a big room with multiple third parties around. Other attorneys from different firms or different organizations, non-related staff people, other clients, other service workers at the building. There really is no attorney-client privilege because it's kind of blown by the presence of these multiple third parties. However, we want to give them an assurance that if they give us this information, we're going to personally keep it within our office. We're not going to be giving their information to a third party. We've had people say, oh, are you going to be putting me on a mailing list? No, we're not going to be contacting them in the future unless they request us to contact them. For instance, by saying they have another legal matter. Well, then we're going to be sending them a letter, for instance. But we're not going to be giving their information to third parties. We're not going to be coming back asking them personally for money, or we're not going to be disclosing anything unless we're required to do so or they consent. They agree to cooperate with us and give us the information that we need to assist them. And then in the unlikely event that the documents ever did need to be recorded, we're not presently guaranteeing that we're going to assist them in the future. We can stop handling their file if they don't cooperate. If they don't give us the information, we can't help them. We can't force people to let us help them. If we feel they lack the capacity to continue, if you run into a capacity issue, and it's very, very rare, in the 1,800 or so powers of attorney that we've done in this program, we've had no more than a half a dozen instances. And we haven't had any, we've had one in about the last 6 months. If somebody is just not getting it though, and it really seems like they're not understanding, call Michael or Ruth over. Ruth Carraher, who is a paralegal who's been working on this project since its inception, is also a retired nurse. And so she has the training to help us. What we normally do in those circumstances, we will err on the side of caution. We will not do the power of attorney, and then we will follow up with them individually at a later date. We don't want to put anybody into a potentially worse position by having them sign the documents that aren't going to be effective because they lack the capacity to do so. But if you get somebody like that, just call one of us over and let Michael or Ruth or whomever sit and talk with them and sort of do a mini assessment. And then, as I said, in most cases what we'll do is we'll err on the side of caution. We'll have them come into the office and we'll talk to them in greater detail and in a more private and confidential manner than we can do in a big workshop. Their participation is entirely voluntary. They can get up and leave if they want. We're not forcing them to stay. However, you will get this question frequently. Oh, I'll just take the documents with me and I'll fill them out. We don't want them to do that. we would greatly prefer that we be the party who are helping them fill them out. Although we use the statutory forms, we do make a couple of changes to them, and our name is on them, so we don't want them being used for sort of nefarious purposes. We do have sets of samples that we can give out if somebody, demands them, but we prefer not to. What we will normally do is we'll give them the 2-page handout that is at the back of the handouts that you all received today, and that has our number, and said, if you want to think about it, talk to your family, and then just call us, and we'll make an appointment to have you come into the office. We would greatly prefer that to having the documents sort of just disseminated without any sort of supervision or control. And then the client signs it, the attorney signs it, and please print your name. I can't read everyone's signature. I can't read my own half the time, so if you print your name, then we can properly credit everybody with the pro bono time that they're committing, that they're devoting to this program. Finally, let's get into the documents a little bit. We're a little behind time, but not so bad. In December of 2010, there was a major change to the power of attorney statute, and as a result, there were new forms. The forms officially go into effect July 1st. However, we have decided to start utilizing them in advance of the sort of official date because the changes that are in the powers of attorney are rather significant, and they're not perfect, but they represent a substantial improvement over the old forms. And under the power of attorney statute, you are allowed to use a different form as long as it's in compliance with the law. We've decided to get a 6-7 month jump on the official launch date because we believe that the improvements that have been made are significant enough that we should use them immediately. And for those of you who have gone through this program before, I'm going to be emphasizing in the rest of our presentation the differences between the old forms and the new forms. Those of you who haven't gone through it before, you'll be fully trained on the new forms. The first and most important significant change is the notice requirement, which is page 1 of the power of attorney for property. In the past, the powers of attorney would have a section that was in parentheses, that was in all capital letters. Those were instructions from the statute. They were not required to be incorporated into the power of attorney. They have now made this notice section, which I'm holding up, part and parcel of the power of attorney, and it is a separate document that is to be initialed individually. And the idea was, from what I can understand, is that it's to give a further explanation about what these documents are and what are the responsibilities of the parties involved. Starts out by saying it's a legal document. It's governed by the Power of Attorney Act. If you don't understand it, ask a lawyer to explain it to you. The purpose of the Power of Attorney is to give your designated agent broad power to handle your financial affairs. The language is very similar to the old notice sections, the old instructions, but they've taken out a bit of the legalese and they've kind of broken down the language a little bit more. They're using terms like financial affairs as opposed to, real or personal property. This form does not impose a duty on your agent to handle your affairs, so it is important that you select an agent who will do this for you. It's important to select an agent you trust. All the things that we emphasize when we give our presentations are now being incorporated into the documents themselves. He or she must act in accordance with the law for your benefit, keep records, etc. Unless you specifically limit the period of time that this power of attorney will be in effect, your agent may exercise it throughout your lifetime. It does not authorize your agent to appear in court for you as an attorney at law or otherwise practice law unless they are licensed to do so in the state of Illinois. And it still incorporates the Section 3-4 of the Illinois Power of Attorney Act, which are the definitions of the enumerated powers that we're going to look at in a moment. you are not required to sign this form, but it will not take effect without your signature. And they are to initial it independently of the rest of the form. The first major change that CDEL has made is we want the principal to initial every page of the power of attorney. Because sometimes there might be a page that's left blank because we didn't have to make any changes. We still want that notification in there that we explained it to them and that they're initialing off on that page. So on page 1, you'll see that there are 2 spots for initials, both directly under here and then also in the corner. Have them initial both. They often say that they think that's stupid, but there's reasons for doing it. Okay. The format of the short form power of attorney for a property is precisely the same as the old form. There's slight changes in language that we're going to talk about, but the format is exactly the same. Line 1, you put the name and full address of the principal. First major change is in the power of attorney for property form, it says, I hereby revoke all prior powers of attorney for property executed by me. That was not in the old form at all. If they wanted to revoke their old powers of attorney, they had to do it by some sort of affirmative action. This is now saying that that is in the power of attorney, that this form is revoking the previous forms. How, once these are launched officially and are used for multiple purposes and somebody's giving multiple people powers of attorney, how they're going to do that, my guess is they're going to have to cross that out and initial it or something to that effect. For our purposes, it's a higher level of protection for our clients. They appoint the 4th line. They have to put the name, relationship, and full address of the agent. So I, John Doe of 123 West Madison, Chicago, hereby appoint Jane Doe, my daughter, of 6500 South Yates, Chicago, Illinois, as my attorney, in fact, my agent. If they don't know the full address, at least city and state, as much information as we can give them for identification purposes. The enumerated powers are precisely the same as the old form, and many if not most of these powers are probably not going to be applicable for our clients immediately. Many of them don't own real estate, many of them don't have stocks and bonds, many of them don't have safe deposit boxes, commodities and options, business operations, etc. Anything that the principal does not want to allow their agent to decide for them potentially in the future should be crossed off and initialed next to it. However, we recommend that they be left as broad as possible because you never quite know what's going to happen in the future. Real estate is always the big one. If the person doesn't own real estate and we cross that out, thus barring the agent in the future from ever possessing, controlling, purchasing, selling real estate on behalf of the principal, and the principal inherits a piece of property, that can be problematic. They've now got this asset that the agent, who's duly authorized and legally authorized to control the assets and protect the assets, they have no ability to protect that asset. They would then generally have to go get a guardianship of the property, a guardianship of the estate limited to that piece of property. However, if somebody has a very strong feeling that they do not want to give their agent a specific power, they have every legal right to cross it out, have them initial next to where they've done where you do the cross out, and they take their chances from there. We recommend it be left as broad as possible, but the documents belong to the principal, so what we're doing is following their directions.
Tom, should we expect a small minority or a large majority of people to actually do this? These people commute, as I recall,
Yes.
going to the centers. Should we?
The majority of the people are probably going to leave all the powers in there. And what we usually say, is there anything you would not want your agent to do for you? And if they say, well, I don't own real estate, we just simply say, there may be a possibility that you may acquire real estate either through inheritance or purchase or whatever in the future. But if they're adamant about it, then we pass it out. So the majority of the people will probably be leaving these virtually untouched. They may say, you know, commodities and options, I don't own any stock, I don't own any commodities, I'm never going to own any of those. Again, they could inherit them though, and it could be problematic. But the vast majority of the people, I would say, will leave these virtually untouched. Section 2 is any specific limitations that the principal may want to put on what they're doing. For instance, if there's a specific asset or a specific account they never want their agent to be able to access, then you can put a specific limitation in there, and you can call Michael over and he can give you the, you know, some suggested language. I would say 98% of the time there's nothing there. We just write NA, not applicable. 3 is additional powers. Where this comes into play for our clients, this would allow the agent to, the principal to grant to the agent powers beyond the enumerated powers. The powers to make gifts, the powers to change beneficiaries, the powers to create powers of appointment. We've had a few cases where people have wanted to make a gift and they want to leave a certain amount of money to their school or their church or to a family member, and they want that gift to continue even after they're no longer able to write the check. So we can write in there with whatever specificity is required that agent is authorized and directed to provide a $25 check to the church at Christmas time, whatever it may be. And again, we will provide any language that's necessary. It's very rare. It's happened maybe a couple dozen times. It doesn't happen very often. Section 4 and Section 5, again, are exactly the same as in the former forms. Section 4 involves discretionary decision-making powers. Your agent will have the authority to employ other persons as necessary to enable the agent to properly exercise the powers granted, but your agent will have to make all discretionary decisions. What I usually suggest is we ask them, would you want your agent to allow anyone else to make decisions on your behalf, or do you want your agent to be the only decision maker for as long as they can be the decision maker? And most of the time they say, no, my son is the person I trust, my son is the person that I want to make my agent. What this does is this would allow the agent, if we left paragraph 4 in, would allow the agent by written authority, by written instrument, to delegate certain powers to a third party or third parties. Most of the time our clients are never going to come into that situation, and hopefully they've named a successor agent in paragraph 8 that would deal with something like if the agent was no longer able to serve. This is really, while the agent is serving, are they allowed to delegate to a third party? I would say 2/3 of the time that people want it stricken out. And we just cross it out and we have them initial next to it. Section 5 is compensation. Your agent will be entitled to reimbursement for all reasonable expenses. Strike out paragraph 5 if you do not want your agent to also be entitled to reasonable compensation. I usually ask the principal, the client, do you want your agent to be paid, to have the ability to be paid for anything that they're doing as agent? And we usually get one of 3 answers. Either, no, that's my son, he should be doing this for me anyway, or I don't have anything, so how would he get paid for this? Or they'll think about it for a second, they'll say, well, if he's paying the bills and he's dealing with insurance companies, then yes, I guess he is entitled to payment. Or they'll say, what's reasonable compensation mean? And that's a bit problematic because it's not clearly defined. It's reasonable in the minds of the agent, keeping in mind that the agent has a fiduciary duty of due care to act for the best interest of the principal. So if they're writing checks and spending an hour a month doing it, $10,000 in compensation is probably unreasonable. $100 a year in compensation may be reasonable. The principal does have the right to put into Section 2 or Section 3 a limit on what the compensation would be if they chose. They can say, I grant my agent the authority to accept compensation, reasonable compensation up to $100 a year. Again, it's very, very rare, but if that is something that they're concerned with, we can put limiting language in there. 6 and 7 are effective and termination dates. The statutory default rule is that they become effective at the time that they are signed, and they remain effective until the death of the principal. Unless they put a limiting effective date or termination date. If they want it to be effective on, say, some sort of debilitating event, that they can't do anything unless there is some reason for the agent to act, you can write into this section in Section 6 certain language. The new forms includes substantially improved language, written determination by your physician that you are incapacitated. I would have probably shortened that to written determination by physician of incapacity, but you can write that in there. If they don't want their agent to be able to do anything unless they are incapacitated, you can write that language in there. The other language that they used to use, and is still in here, is court determination of disability. That's problematic because that would involve court action prior to the agent being able to act. And then finally termination date, it automatically terminates upon death. If you write anything in Section 6 and Section 8, make sure that they initial in the parentheses that they're authorizing the later effective date and termination date. Section 8 is where we write in the any successor agent, and hopefully it can be written with the same sort of specificity as the agent, name, relationship, and address. Again, if they don't know the full address, then they can, at least city and state should suffice. Section 9 is optional. If they wish, they may nominate their agent to serve as a guardian, should the court ever require a guardian to be appointed. They would be serving without bond or security, but this is only a nomination. And where this comes into play, and what I usually ask the client is, would you want your agent to serve as a guardian if the court ever said a guardian was needed? And they'll often say, well, why would that ever be possible if they're already my agent? And there's a couple of possibilities. The first possibility is that we've made a change to the power of attorney, like we've crossed out real estate, and they've inherited property, so that potentiality has come to be, in which case they have to apply for the guardianship, petition for a guardianship. The second possibility, and then this is simply saying, I as a competent adult would want my agent to serve as my guardian, just like they're serving as my agent, should the court ever require it. The second possibility is that there's some defect in the power of attorney. In that case, the court may look at this as potential evidence in making a determination over who would be an appropriate person as guardian. And the third possibility would be if there was some sort of court action due to an alleged breach of fiduciary duty, that the agent is not acting in he's not utilizing due care. In that case, the court's not going to accept the nomination, and they're going to appoint the person that is most appropriate. I've only had maybe a couple of dozen where they've not wanted to appoint their agent as guardian, but that's their choice. What they can't do is nominate somebody else. It's neither or. Either they keep it in, which nominates the agent as guardian, or they strike it out, which doesn't. And then they sign it. There is only a requirement that there be one witness, but the statutory form now has a suggestion that there be two. We go ahead and use two witnesses now. The reason that they put this in there is that some states require two witnesses, and they have found instances where they've been valid in Illinois but not valid in another state. So it's just one way of them possibly extending the usefulness. I would prefer that the attorney explaining the documents not serve as the witness. I would prefer it be somebody completely independent. They have changed significantly the qualifications for a witness. It can no longer be an attending physician, an operator of a healthcare facility, a parent or sibling, or an agent or successor agent, for obvious reasons. None of those apply to us, but it's just a bit of an improvement in the way that they've done the witnessing. If there isn't, and there's plenty of people there who serve as witnesses, we just get up and sort of switch tables when we need a witness. And then finally it gets notarized on page 5, and we will have notaries on site. Pages 6 and 7 are substantial changes. These didn't exist prior to the new forms. The first one is a notice to agent. It is given to the agent to explain to the agent exactly what they're being asked to do. It also includes things like, if they have to sign something, how do they sign it? This is a question that we would get frequently. Well, how does my agent actually serve as my agent? If they're signing a check, how do they sign it? This helps explain that. And then finally on page 7 is the certification and acceptance of authority. This the agent fills out when they start to act under the power of attorney. And it helps to clarify what the agent is doing and the fact that the agent is accepting the authority. All that we do at this point is we just have the principal initial down at the initial section. They're left blank until the agent is starting to act. And then finally is the statute itself.
And they send it to the agent?
Yeah.
Yes.
Yeah. What happens is the agent must have possession of the original power of attorney in order to act under the power of attorney. So when the time comes that the agent is starting to act, they will get the original document, including this certification and acceptance of authority, and that's when they sign off on it. And that's when they can start utilizing the powers. The other thing is that it may provide a bit of protection for the principal, because they can hold on to this until it needs to be used. Okay.
Quick question.
Yes.
So if the agent doesn't sign this certification, then the power of attorney is null and void?
It's not null and void. It's just that the agent cannot start to utilize the powers. It's still a valid power of attorney, but it's still an effective power of attorney, but the agent hasn't accepted the authority of agency yet.
So it sounds like it's important for us to tell the principal
To hold on to that.
hold on to that and make sure they have it and sign it before.
Yeah, and it's all going to be included in the power of attorney. They're all going to be stapled together, so
Okay.
it shouldn't be a problem like they're not going to tear it out and lose it.
Okay.
But yeah, it's important that they be made aware that this is an affirmative action that the agent may have to do at some point in the future if they're acting under the power of attorney for property.
So the principal has to send this to the agent and make sure that they sign it and get it back?
No. They sign it when they are beginning to accept the power of attorney and utilize the agency. So it stays in with the power of attorney until the agent is ready to act under the power of attorney. For whatever reason that they're acting under the power of attorney.
Excuse me, how often do the principals actually bring with them and say, this is my son, I want him to be the agent?
That's a fantastic question. Probably about 5% of the time. And if they do, if the agent is there and they're going to be acting immediately, then they can sign off on that certification now. But normally, they wouldn't do that. And all they would do is on page 5, there's a specimen signature section where they can give a specimen of their signature, and then the principal can certify that that in fact is the agent's specimen signature. It's not required that they do it, but if they're there, then they often will. I saw one other question. Yeah?
Yeah, just go over section 6 again.
Sure.
If it's left alone, then it becomes in effect immediately.
It becomes effective immediately.
Right, so I think it would be important to explain to the client, do you want this to be effective immediately or only upon your incapacity?
Exactly.
And if they want that, then it looks like you could just pencil in that text below.
Exactly. Precisely. And then have them initial it. Yes.
Rather than.
Do most do?
No, most people want it effective immediately, even though the other thing is that they're not giving up their rights to still make their own decisions just because they've appointed an agent and just because the agency is effective. There is a slight possibility that the agent could prematurely utilize the power of attorney, but if they've picked the right person as agent, the chances of that happening are very slight. And two, any action that they did take that would be premature would not be would be breaching their fiduciary duty, and the principal could then revoke the power of attorney at that point. But it is important to let them know that that is, that's a possibility. I would say it's probably, the majority of the people leave it blank. They want it effective immediately, but we do have people who have that, and so I'm glad that they've actually changed the language in the statute. We've been using physician statement of capacity as our suggested language for as long as we've been doing this program. It's nice that they've actually incorporated that same language into the statute. That has nothing to do with us, it's just sort of happenstance, but it's far preferable than court determination of disability. Okay.
Excuse me, did
Yes.
that wording for 6, physician's determination
Of incapacity, yeah. It's written right into section 6.
These copies are all double-sided. Do you have a supply of the standalone?
Yeah, there'll be standalones at the workshop. The ones that we're going to be actually filling out for people will all be standalone documents, yes. Okay, in the last, we're running a bit short on time, so I want to get through the power of attorney for healthcare pretty quickly. Again, the first change to the document is that there is a notification section that must be must be initialed by the principal. The language is very similar to what the old language was in the instructions, that it's a legal document, that you're designating an agent, that it's important to select an agent that will do this for you and somebody that you trust. You can limit the time period, it's governed under the law, and that it cannot take effect until it's signed. We fill out the first part of the power of attorney for healthcare exactly the same way with principal's name and address, agent's name, relationship to principal, preferably, and address. There are a couple of major changes on this second page of the power of attorney, the first page of the actual form. The first one is section C. It used to say, my agent shall have full authority to authorize an autopsy and direct disposition of my remains, period. And that was the end of the section. They've now gone on to say that they intend that the power of attorney to be in substantial compliance with the Disposition of Remains Act, and that all decisions with respect to disposition of my remains, including cremation, shall be binding. So this is kind of clarifying that the agent is the authorized person to direct disposition of remains, and anyone who is who receives a copy of the document, the funeral home or whatever, are directed to act under it and to follow the instructions of the agent. Basically, so there aren't these, intra-family fights. If they don't want their agent to control the disposition of their remains, they can always scratch that out and initial next to it. And then Section D is a major change. It used to simply say, my agent shall have the same access to my medical records that I have, including the right to disclose the contents to others, which is in Section A. They have now gone in to say this is intended to be in substantial compliance with HIPAA, with the Mental Health and Developmental Disabilities Confidentiality Act, etc. And then it's directions to the physicians that they are to release information to the agent, and that the agent is authorized to accept and disseminate that information according to the directions of the principal.
Excuse me, quick
Yes.
question. Under B, the first item, any organs, tissues,
Oh, yes.
does that extend to mean the entire body?
Yes, correct. And then they can write in there any limitations that they want to in that second section.
Or they could check the third box,
That
right?
they don't have any,
Yeah.
right.
I've had a lot of those.
Yeah.
They don't want to.
The interesting thing is another change is, in the event that none of the options are initialed, it shall be concluded that you do not wish to grant your agent any such authority. Whereas it used to be, if the I do not grant my authority, or I only want to do a specific one, that it was sort of left up to the agent. So they're now making it a limitation on what the agent can potentially do. Section 2 is any specific limitations. People who have specific preferences about various types of treatment. Anything that they don't want, they can write in there. They don't want blood transfusions because of their religion. They don't want certain types of invasive procedures. And what I usually say is there any decision you would not want your agent to be able to decide for you regarding your medical treatment or health care? And if they have anything that's specific, we write it in there. And then we have them initial next to it. The subject of life-sustaining treatment has a particular importance. For your convenience in dealing with that subject, some general statements concerning the withholding or removal of life-sustaining treatment are set forth below. They can only pick one of the three. They have made a substantial change to this one as well, particularly number 2. So for those of you who've gone through this program before and you've seen the old section number 2, it simply said, I want my life prolonged, I want life-sustaining treatment provided or continued unless I am in an irreversible coma. Well, the problem is that irreversible coma doesn't actually exist under reasonable medical standards, current medical standards. So they've changed the language substantially. The first one is exactly the same, that I don't want my life prolonged, nor do I want life-sustaining treatment provided or continued if my agent believes the burdens of the treatment outweigh the expected benefits, taking into consideration relief of suffering, expense involved, and quality, as well as possible extension of life. The second one mirrors almost exactly what a living will states, living will declaration. I want my life to be prolonged and I want life-sustaining treatment provided or continued unless I am, in the opinion of my attending physician in accordance with reasonable medical standards at the time of reference, in a state of, quote, permanent unconsciousness, suffer from a, quote, incurable or irreversible condition or terminal condition, as those terms are defined in the Illinois Power of Attorney Act. If and when I am in those states or conditions, I want life-sustaining treatment to be withheld or discontinued. That is virtually the same language as what a living will declaration states. So it's a little bit more narrow than the first choice, but it's substantially improved over irreversible coma. And then the third one, I want my life to be prolonged to the greatest extent possible. They've added, in accordance with reasonable medical standards, without regard to contingent chances for IF or recovery or cost of procedures. Read all three of them in their entirety before the person makes their decision, because oftentimes they will have a very, very specific idea that they'll say, you'll get, I don't want my life to be prolonged, I want that one. And that's what they will pick. Explain to them, let me read the three of them so you can make the most informed decision. Now, I'm glad that you've thought about it, I'm glad that that you've given consideration to this, but let me make sure that you understand all three of them. The other thing is that if you read the note section above, these statements serve as guidance for your agent, who shall give careful consideration to the statement you initial and engage in healthcare decision making on your behalf. So the power is still there with the agent. These are intended to help guide them. And the fact that they put that language in the note section is kind of helpful, because it kind of clarifies it, at least hopefully, for the principal. The effective date and termination date, again, they can write in there written determination by physician of incapacity, but that's kind of expected anyway. I mean, the doctor isn't going to let the agent make healthcare decisions as long as the principal is making healthcare decisions. Do not put termination death, because of those three residual powers. If you write in paragraph 4, this power shall terminate on my death, you cut off the ability to make decisions about anatomical gifts, autopsy, or directing the disposition of the remains. Section 5 is where you write in any successor agents. They can again appoint a guardian. They can nominate a guardian of the person should the court ever require a guardian to be appointed. Again, you just simply ask them if they would nominate their agent to serve as their guardian should the guardian ever be appointed. Yeah?
And just a quick question for the timing when this becomes effective.
Yeah.
Just from previous experience, a lot of people say, oh, I want effective immediately.
Right.
But they also have somewhat, I don't want to say it's contradictory, and I guess I'm kind of just looking for some guidances. The provision allowing them to, well, can they put me into a home? And I noticed the language under here said, under 2, had some inference of voluntary admission to a mental institution. And one of the questions I remember getting is, oh, by the way, can my son just put me into a nursing home?
The answer to that question is no, because one of the interesting things about the health power of attorney, as opposed to like the mental health declaration, is that the power of attorney for healthcare is revocable. If they're trying to put mom in a home and she doesn't want to go, she can revoke the agency. In which case, then they would have to go and get a guardianship, and if it's determined that mom is incapable of making decisions and a guardian is appropriate, then they may appoint the guardian, and then the guardian can make that decision. But even a guardian cannot do an involuntary committal to a mental institution now. So it sounds contradictory, but it really isn't, because there is that sort of built-in protection there. And then they sign it, it gets witnessed. If the agent is there, they can give the specimen signature, and then we notarize it at the bottom. The last document is the living will declaration. Yeah.
Before you move on, just a quick question on number 2. So,
sure.
If they put in limitations
Yes.
in the first part, they still should select one of the 3 options, correct?
They still have the right to, yes. If they put a limitation in there that I only authorize life-sustaining measures for 7 days, they still have the right to pick one of those 3. If they say my agent is not authorized to make any decisions about life-sustaining treatment, then they wouldn't pick one of those because they're not authorizing their agent to do it. I've never had somebody do that though. In all of the ones that we've done, we've never had somebody where they've just out and out flatly denied their agent the right to make the decision. They usually will pick the third one in that case because they want everything possible to be done. But if they have a limitation, depending on what the limitation is, they would still have the right to pick one of the three. And they also have the right not to pick any of them. If they pick none of those three decisions, none of those three things, they're just simply leaving the decision up to the agent. Yeah?
For clarity on number 3.
Sure.
If it's effective immediately on signature, you don't write.
You don't put anything in there. Just leave it.
Nothing. You just
No.
leave it blank.
You could, if you wanted to put today's date, you could, but it's not necessary because the default rule and then the instructions specifically says it becomes effective upon execution.
But it's okay. If
But
you
it's
want to
okay,
write date,
yeah.
or if you want to write immediately.
Yeah, you can write immediately, you can write today's date, but don't write death under the termination because that would materially affect the ability of the agent to perform some of the functions under the code.
Number 4, we should just leave blank.
Leave blank, exactly, yeah. I mean, there are cases where you might put an effective and termination date, like if somebody's going to the hospital and they're going to be temporarily incapacitated, or they want someone else to make decisions while they're recovering, in which case you would say, it's the day they go into the hospital and it's 3 days after they get out, something like that. But for our purposes, it should just be left blank. Okay, we're kind of out of time, unfortunately, but I do want to just spend 2 minutes, if that's okay. And if you guys want to get up and start getting lunch or something, go right ahead. But I do want to spend like 2 minutes talking about the living will. For 2 reasons. First of all, because a lot of attorneys feel that a living will declaration is superfluous for people who have a power of attorney for health care. The statute now states that, the new power of attorney statute now states that if there's a conflict between a living will declaration and the directions under a power of attorney for health care, the power of attorney for health care controls. We always assumed that to be the case. It is now in the statute itself. The second thing is, although the language, if at any time I should have an incurable and irreversible injury, disease, or illness judged to be a terminal condition by my attending physician who has personally examined me and determined that my death is imminent except for death-delaying procedures, and I direct that those procedures which only prolong the dying, possibly withheld or withdrawn, I be permitted to die naturally, etc. Although that's very similar to the second choice of the power of attorney guidelines, we'll call them, this is simply a statement of intent. It's not actually authorizing anybody to do anything. It's saying that it's my intention that the declaration shall be honored by my family and physician, but it doesn't authorize anybody to make the decision. The power of attorney for health care does. But I think it's still valuable for people, even if they have the power of attorney for health care, for 3 reasons. The first reason is, if the power of attorney is no longer valid for some reason, the agent has predeceased and there's no successor agent, it's been declared to be terminated by a court, for instance. The principal has revoked because they don't want that person, that agent, making some decision. The living will declaration is still their statement that they would not want these death-delaying procedures. They wouldn't want to be hooked to the machines, as the people will often say. The second issue is, if somebody is making the decision about whether to continue or end these types of procedures, it may give them some clarity and some sort of personal assistance if they have mom's statement that mom made 5 years ago saying, if I'm in that state, I don't want these procedures. I know personally it would probably make it easier for me if I had to make that decision for my own mom, if I actually had her statement saying that. And the third reason is, anyone who is being asked to end the life support, the physician, the healthcare service, they have the, although everybody has a right inherent in the Constitution under the Missouri versus Cruzan decision to refuse medical treatment and suffer the and accept the consequences of such a refusal, anyone who's being asked to actually do that, to end the life support, to turn off the machine, whatever it may be, has a right to request and demand clear and convincing evidence that this is in fact what that person wanted. That's what the Living Will Declaration does, assuming there's no power of attorney anymore. The power of attorney still controls. The Living Will Declaration is only there for guidance or in the event that the power of attorney is no longer effective. It is filled out very simply. They sign it, they write their address, it's witnessed by 2 people, it is not notarized.
And for addresses, we can put our business address.
You can put business addresses, or you can put CDEL's address, 79 West Monroe, Suite 919, Chicago 60603. That's perfectly acceptable. Don't have to put a home address.
That address is on the front.
Yeah.
People who are writing to.
Yep. It's also on each power of attorney too. So I'm going to be around for a few more minutes, so if people have additional questions, I'm happy to answer them. But I know you guys want to go to lunch and stuff, so I will end sort of the formal presentation, but I'm going to be around for at least another 15 or 20 minutes to answer individual questions. So thank you all very much.
Thanks, Bob.